Choctawhatchee Bay's shoreline is being reshaped by industrial pollution. Looking closely at the marshland, clear water is suddenly interrupted by a dark runoff plume. For over 20 years, Walton County has funneled public stormwater onto a private bayfront property owned by Doug Liles. The county used Mosquito Control Ditch 10 as an unauthorized conveyance, never seeking an easement or offering compensation to the landowner. This chart represents the standard retention requirement for the local drainage basin. To prevent flooding, the system must hold 6.7 inches of rain over a 24-hour period. Engineering reports from 2015 and 2018 prove the county's infrastructure fails this requirement, sending the excess volume directly onto Liles' property. This constant surge of unmanaged water has physically destroyed the land. It has killed mature trees and caused severe shoreline erosion, stripping the property of its natural stability. Florida law classifies this as inverse condemnation. It is the legal framework used when a government physically invades private property and destroys its use without paying for it. The county did not file any paperwork to buy this land. They simply seized its utility by turning a private lot into a public drain. In 2015, Liles sued Walton County to force repairs to the drainage system and seek damages for the physical taking of his shoreline. Following the lawsuit, the county reversed its support for a USDA-backed rural farm project Liles was developing, a project the county had previously approved. This marked a shift in tactics. The county began using code enforcement and the permitting process to impose daily fines, creating a financial burden that escalated as the litigation continued. Liles was now facing a two-front war. While his property continued to flood physically, he was simultaneously buried under a flood of daily code enforcement fines and bureaucratic delays. On February 27, 2018, the Board of County Commissioners held a hearing to vote on the Point Washington Preserve development order. They denied the permit. Liles alleges this denial was tainted by ex parte communications. In a quasi-judicial hearing, it is illegal for officials to hold secret, undisclosed discussions about the case with outside parties before casting their votes. Using the power of a government board to punish a citizen for seeking legal redress constitutes a violation of the First Amendment. As the parties move toward a third mediation, new evidence has surfaced that removes the county's legal leverage. In February 2025, an appellate court ruled against Walton County in a similar case called Osborne. The court found that the county's development denials suffered from the same procedural defects Liles is challenging. This radar chart shows a comparison between safe baseline toxicity levels and test results from catfish in Choctawhatchee Bay. In April 2026, state-accredited labs detected 14 PFAS compounds, with PFOS levels reaching 66.1 micrograms per kilogram. These chemical toxins are found alongside Vibrio vulnificus, a dangerous flesh-eating bacteria that flourishes in the bay's current conditions. Under the Florida Whistleblower Act, reporting a substantial and specific danger to the public's health triggers immediate legal protections. By documenting these environmental hazards for the Department of Health, Liles shifted his legal standing from a private landowner to a protected whistleblower. Liles enters mediation holding state-certified evidence of a toxic public health crisis and the legal immunity provided by whistleblower status. Inside the mediation room, Liles has presented a 5-part settlement. It's an integrated proposal addressing the physical damage and years of regulatory obstruction. The 5-part settlement starts with a $2 million buyout to convert the lot into a public stormwater park. Next, the county must commit to re-engineer the drainage basin, void the 2018 denial, and vacate fines. Finally, it demands compensatory damages and strict evidence preservation. This proposal seeks to end 2 decades of property destruction by forcing the county to replace a recurring public liability with a restorative bayfront park.